Welcome to Bloomberg Law. I'm Pacchia. Congress and agencies like the Federal Trade Commission continue to propose new privacy measures for the Internet age. Joining me now from Washington, D.C. to discuss what should be done to protect personal data is Christopher Wolf of both Hogan and Lovells and the Future of Privacy Forum, where he is the co-chair. Christopher, thanks for joining us. Welcome.
Lee, thanks for having me.
So you are the director of Hogan Lovells Privacy and Information Management Practice Group. Tell me about your practice. What type of clients do you have, and what exactly do you do for them?
Well, it's the rare business today that doesn't have data, personal data, on either employees or consumers. And so what our practice does is advise our clients on how legally and in terms of best practices they can collect, use, share, and retain that data. There's a special focus on health privacy, and my co-director is Marcy Wilder, who focuses on that part of our practice. Mm-hmm. And then financial information, obviously, is incredibly sensitive. And the reason there is a privacy practice in our law firm and some others is because technology has made it possible to collect so much information about people and to share it and to use it and to retain it. And there are more and more laws that regulate that use.
Right. We came up with an interesting quote from someone at your organization stated in a previous discussion, "In the era of big data," I'm quoting here, by the way, "privacy is too important to be overshadowed by claims of legal framework superiority." Could you explain what that means?
Well, that was actually me, I think you're quoting, and that came from remarks I gave at the EG8 in Paris in June. And what prompted that observation was the kind of running dispute that exists between the EU and the US with respect to protecting privacy. In the EU, there's a comprehensive statutory arrangement that covers every piece of data. And it means that databases have to be registered and that there is incredibly granular regulation of data. In the US, we protect sensitive information most of all: financial data, medical data, data about kids. Mm-hmm. And we focus our enforcement on the things that matter. Mm-hmm. But today, for a business that operates globally, there has to be a legal mechanism in place for the cross-border transfer of data from the EU to the US, because the EU says the US does not have adequate protection. Mm-hmm. And the gist of my comments had to do with the fact that we may approach the protection of privacy differently, but we take it very seriously here in the U.S. And I'm not sure it serves anybody very well to say mine is better than yours.
Right. So we're going to get
legal framework.
We're going to get to both systems. There are two ways of approaching this: one of a European mindset and another from the American perspective. But is there a baseline protection that exists out there that covers basically citizens around the world when we're looking at the right to keep email addresses, phone numbers, physical addresses private?
Well, indeed, the legal frameworks in both areas, in the EU and the US, are premised on fair information practice principles, which are OECD principles. In fact, they derive back to the 60s from the Department of Health, Education, and Welfare principles for fair information practices. And fundamentally, the practices say that individuals should know what information is being collected about them, how it's being used, with whom it's being shared, and how it's being stored. And they ought to have a degree of control over that collection and use. Mm-hmm. And that's really the premise of every privacy regime around the world. Mm-hmm. So what now it differs in terms of its specificity and in terms of the flexibility.
Right, that's where I want to go next. Some consider Europe to be ahead of us in some aspects on privacy law issues. What do they do differently from the United States?
Well, they have a regulation for every piece of personal data, and they define personal data more broadly than we do in the United States. I personally am not convinced that results in better privacy protection, because where the rubber hits the road is where there's enforcement. And here in the United States, we have the Federal Trade Commission enforcing against companies that engage in egregious privacy practices, or who promise one thing and do another under the false and deceptive practices jurisdiction of the Federal Trade Commission. And frankly, I think that common law of consent decrees and enforcement by the FTC has created a set of rules and principles that businesses understand to a very large extent here in the U.S. and therefore they take privacy very seriously. I think there are lots of businesses in Europe that may have these rules that they are supposed to comply with, but because there's not a lot of enforcement, I'm not sure how respected a lot of those rules are.
So as a general matter, companies in the United States don't give consumers or recognize a right for consumers to delete their information once it's known that they have it. Should they change that policy? Is there any sense in taking a different approach?
Well, I think that varies from company to company, and it varies on the type of data that's being collected. Anonymous data that's done for analytical purposes, that's done to predict trends in disease, for example. I'm not sure that as a public policy matter, we want to give individuals the right to delete that data and to make it not useful if it's being protected and if it's not identifiable. Other data, for example, when you give data out for a particular service, and I'm thinking social networking, for example, and you decide you no longer want to participate in that kind of social networking, then perhaps you should have the right to say, don't keep the data, I want it all back.
One would think that's just a matter of good business. It could almost be similar to the way companies took up green initiatives in the banner of environmentalism. So to speak, they could be along the same lines with privacy issues. We haven't quite seen that yet, at least in public discourse.
Well, I think we're getting there, actually. I think the public's consciousness about privacy is being raised thanks to the media. Been a lot of newspaper articles and TV news stories about privacy in the last year. There have been a number of congressional hearings. And I think businesses understand that privacy is good business and that consumers will reward businesses that are straightforward about what they do with information that they collect and where they give individuals some degree of control over the use of that. And I think we're going to see that more and more, and obviously I think that's a good thing.
Right. There's already some legislation on the table, a bill out there called the Do Not Track Kids Act of 2011. What's in there, and what should we be paying attention to?
Well, clearly protecting kids online is hugely important. I am not sure that the Do Not Track Kids bill is the way to go about it. And in fact, the Center for Democracy and Technology, which is a very middle-of-the-road group that is pro-consumer, has done a detailed analysis showing that there's some real technical problems with the proposals. For example, there's this concept of an erase button in the Do Not Track Kids bill, where people could insist that data be eliminated, and where if companies don't eliminate it, they're subject to fines and penalties. Well, with the way that data is shared and stored and syndicated, it's going to be very hard to certify that, in fact, it has been deleted. And again, there's some information that it's in the public interest that it remain. For example, if a newspaper reports on a story, you shouldn't have individuals with the ability to come in and say, I want you to censor that article in the archive so that no one can read about it. We've seen that the so-called right to be forgotten in the EU has some very perverse ramifications, and frankly is probably inconsistent with the right to free expression that's protected by our First Amendment.
Picking up on the idea of an erase button, so to speak, should there be something like that for adults as well? It's interesting that there's a line of distinction between children and adults when talking about that type of function.
Right. Well, first and foremost, privacy protection, I think, is a multifaceted thing, and that individuals have responsibility themselves to make sure that certain data doesn't get released. And so, people need to be careful what they put up on Facebook, what pictures that they share, and certainly they should have the ability to take down material from their own Facebook accounts and to be untagged when other people tag them in pictures. But it gets incredibly unwieldy if you give individuals the right to erase any evidence of their existence or episodes in which they've participated. And I'm not sure it's in the public interest, again, to give that kind of right, because there are lots of reasons why we want to be able to check up on potential employees, potential babysitters, potential teachers, and so forth. And if we have a Swiss cheese record that's created because people have asked for the right to be forgotten, you've got some very legitimate interests that I think will fall by the wayside.
Right. It begs the question, though, that in the worst case scenario, when you have a company that is effectively brokering your personal data and posting it in sensitive corners of the internet, what is the legal response from a victim in that scenario? Is there anything that they can do?
Well, you know, Congressman Rush from the FTC made a good point, I think it was yesterday, where he said we really need to study what is in fact going on with respect to the collection of data online. You know, is identifiable data actually being collected against people's will? Or are we talking about anonymous, de-identified data that's being used for legitimate purposes like market analytics to determine whether or not a website is effective, whether people actually complete their purchases when they go online? You know, I don't think we need to, that we can jump to conclusions that that information is being misused in huge ways by legitimate companies.
But some businesses do that as a matter of practice, right? I mean, that is effectively the way some businesses operate.
Well, you're always going to have outliers, and you're always going to have wrongdoers. And the question is whether you throw the baby out with the bathwater. You know, some of these legislative proposals that we're seeing are incredibly broad, and I think there's a legitimate concern that if implemented, they could have, they may deal with some of these bad guys, but they also could have unintended adverse consequences. And at a time when e-commerce is one of the bright spots in an otherwise not so bright economy, we want to be careful not to do anything that might inhibit that.
That's true. They seem to be the only people. Go ahead. They seem to be the only people in America making money these days, so you certainly don't want to upset that apple cart.
Well, that's right, but also privacy is confidence by the consumer that their information is being protected and not abused is equally important to the success of the e-commerce economy, and businesses need to realize that. And I'm actually heartened by the fact that a lot of businesses are engaging in self-regulation and promulgating codes of conduct. This is something that the Department of Commerce has endorsed. The FTC has also said this is a good thing. And frankly, I think the odds of getting legislation in privacy, given how Congress works these days, are pretty low. So we really ought to applaud these self-regulatory efforts and support and endorse them.
All right, this is wild stuff. I think we're going to be talking about this for a long time going forward. Chris, I want to thank you for your time today. Thank you, sir.
Thank you for having me. Thanks, Lee.
That's Christopher Wolf of the Future of Privacy Forum and law firm Hogan Lovells. You can learn more about these issues in Bloomberg Law's Technology Law Report. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.